What started as a routine oversight hearing quickly turned into one of the most explosive confrontations yet over the Jeffrey Epstein files, as Congressman Dan Goldman directly challenged FBI Director Kash Patel over transparency, secrecy, and whether the American public is still being kept in the dark about who exactly was connected to Epstein's trafficking network.
Gentleman yields back. The gentleman from New York is recognized. Mr. Goldman.
Mr. Patel, does Donald Trump appear anywhere in the Epstein files?
I'm sorry, could you say that again?
It's not a complicated question. Does Donald Trump appear anywhere in the Epstein files?
I didn't say it was a complicated question. I just didn't hear you, so my apologies. We have released where President Trump's name's in the Epstein files and everybody else, and all credible information that we are legally allowed to release has been released.
All right, so let's go through that. You're referring to court orders that prohibit you from releasing grand jury testimony under Rule 6E. Is that what you're referring to when you say as the law allows?
That's a piece of it.
Really? What other evidence do those three court orders you cited prohibit from being released?
Information that was collected pursuant to those search warrants that were limited in fashion.
Wrong. That's not what the court order says, and that's not under 6E.
And you're talking, and I said that's 6E, and I said there was others, and I'm answering that. There are sealed court order documents. There are protective orders.
They are unsealed as part of discovery given to Ghislaine Maxwell. They are no longer sealed.
That's just not true. We can argue about it all you want.
Okay, well, you agree that there are, so your testimony here is that the reason why you are not releasing all of the videos that you have acknowledged, there are so many, and that the FBI spent thousands of hours of reviewing, the photographs, the photographs that you have. You're saying that you're not releasing those because there's a court order requiring them to be sealed? Is that your testimony?
Never said that about the videos. On the totality of the videos, of the thousands of images that were seized pursuant to the search warrants executed at the time, the overwhelming majority of that video is pornographic material that was downloaded from the internet and child sexual abuse material. We will never release that.
Well, as you should not release the victims, but if there are videos that relate to others who Epstein trafficked to, such as maybe Prince Andrew, or photographs, that you have total control to release.
Yes, and if it exists.
And so why haven't you released it?
Why are you supposing that that is a fact when in fact it is false? Are you saying that?
You're saying that none of the videos relate to anything relevant to the Jeffrey Epstein trafficking ring?
Every single video that we have collected pursuant to the prior search warrants has been examined for the last 10 years. And every single video has been utilized for whatever prosecutions were able to be legally brought.
I'm not asking about prosecutions. I'm asking about why you aren't releasing the full Epstein files, including the names of people who were involved in the sex ring that you promised to do before you became FBI director.
I just told you, I'm not going to release downloaded porn.
I'm not asking about that. Fine. I'm asking about all the other files.
What other videos? Tell me. Tell me.
That's what I'm asking.
Tell me.
You're saying there are no videos that would be relevant to anyone else involved in the Jeffrey Epstein sex ring.
Pursuant to Mr. Acosta's collection of information based on the search warrants. That's all we have in our possession.
And I'm asking you, that stuff.
That's all we got.
I'm not asking all you got. I'm asking you in that stuff, there's nothing that's related to any other sex traffic, any other people engaged with Epstein in underage sex.
That's correct. To my knowledge, no.
Okay. Let's talk about the witness interviews. 302s of witness interviews. Those are not subject to the court order. Those are not subject to any fictional sealed order for a search warrant. Why aren't you releasing those with the redacted names of the victims?
We are releasing as much as legally allowed. That's why we went back to the courts.
How is that not legally allowed?
Sir, do you know how court orders work? Do you know how protective orders work?
Actually, Mr. Patel, I was a real prosecutor for 10 years. I know exactly how.
So I was a fake one?
And I want to understand what the court order prevents you from releasing witness statements that the FBI took.
You should know that as a real prosecutor, when the court hand downs a protective order and a motion to seal, the material is sealed unless that judge waives it.
So your testimony here is that all of those witness statements are under a court order, a protective order.
We are providing everything we can legally provide.
No, that's not my question. My question is, why are those witness statements that are not grand jury testimony, that if they were under a protective order are no longer under a protective order, why are they not being released?
How are they not under a protective order?
Why are you not going to the court like you did for the grand jury testimony to unseal those records?
The DOJ did go to the court.
No, not on those records. Why aren't you going? You just went on grand jury.
Time of the gentleman has expired.
You are hiding the Epstein files, Mr. Patel.
Time of the gentleman has expired.
You are part of the cover-up.
Can I respond?
Sure can.
Any allegations that I'm a part of a cover-up to protect child sexual trafficking and victims of human trafficking and sexual crimes is patently and categorically false in the work of my
So I hope you will talk to them when they have requested to speak with you. Because the victims have requested and you are not responding to them.
Director, yes or no? Is the
And what made this exchange so striking was not just the tension. It was the fact that Goldman came prepared with a very specific legal argument. He wasn't simply shouting political talking points. He was walking through what can legally be released, what cannot legally be released, and why Democrats increasingly believe the FBI and DOJ are hiding behind vague references to court orders, instead of fully explaining what information still remains secret. The hearing began with Goldman asking a question millions of Americans have been wondering for years. Does Donald Trump appear anywhere in the Epstein files? Patel responded carefully, saying that anything legally releasable involving Trump and others had already been released. But Goldman immediately drilled down into the details, because this is where the real fight is happening. Not over whether some documents exist, but over what exactly the government claims it legally cannot disclose. Goldman focused heavily on Rule 6E, which governs grand jury secrecy. That's important because grand jury testimony is one of the few categories of evidence that courts protect very aggressively. Patel tried to argue that additional materials were still restricted under court orders and protective orders, tied to search warrants and discovery materials. But Goldman pushed back hard, arguing that many of those materials are no longer sealed, especially after being shared in the prosecution of Ghislaine Maxwell. In other words, Goldman's argument was essentially this: if those documents were already disclosed during criminal proceedings, why is the FBI still refusing to release them publicly with victim names redacted? That distinction matters because this hearing exposed a deeper issue that goes far beyond partisan politics. Americans across the political spectrum increasingly distrust institutions when it comes to powerful and wealthy figures. The Epstein case became symbolic of that distrust because Epstein's social circle included billionaires, royalty, celebrities, and politicians from multiple parties. People saw someone who operated for years in plain sight, surrounded by influence and privilege, and they still believe the full story has never been told. Goldman's frustration escalated when Patel repeatedly lumped all unreleased material together with child sexual abuse material and pornographic evidence. To be clear, nobody in the hearing argued that explicit abuse material should ever be released. Goldman made that point repeatedly. What he was asking about were witness interviews, investigative records, photographs, travel logs, communications, and evidence potentially identifying adults connected to Epstein's trafficking operation. And that is where the exchange became especially revealing. Goldman kept narrowing the focus. He asked Patel whether there were videos or evidence involving other adults connected to Epstein's trafficking network. Patel ultimately answered that, to his knowledge, there was nothing else in the FBI's possession connecting additional individuals to criminal conduct beyond what had already been prosecuted. That answer is politically explosive because it directly clashes with years of public speculation, online theories, and repeated promises from Trump allies that major revelations were coming. Remember, before becoming FBI director, Patel had strongly signaled that more transparency was needed regarding the Epstein files. Democrats are now using his own earlier rhetoric against him, arguing that once in power, the administration suddenly became far more cautious and secretive. Goldman then shifted to another key issue that casual viewers may have missed, but legal experts immediately noticed: FBI 302s. Those are official summaries of witness interviews conducted by agents. Goldman argued those interview summaries are not automatically protected by grand jury secrecy rules, and therefore could potentially be released with redactions. This was not random questioning. Goldman was trying to establish that the administration may not even be attempting to unseal large categories of evidence that could legally be disclosed. Patel responded that the DOJ was releasing everything legally possible, but Goldman kept pressing him on why the government was not proactively returning to court to request additional unsealing orders. And then came the moment where the hearing completely broke down. After Patel repeatedly avoided directly answering whether specific witness statements remained under active protective orders, Goldman accused him outright of hiding the Epstein files and being part of the cover-up. That accusation instantly transformed the hearing from a legal debate into a political firestorm. Patel fired back emotionally, rejecting any suggestion that he or the FBI were protecting child traffickers or covering up crimes against victims. And this is where the exchange became bigger than just two politicians arguing. It exposed the impossible position institutions now face in highly politicized investigations. On one side, victims and transparency advocates want maximum disclosure. On the other side, law enforcement agencies cite legal limits, privacy protections, and evidentiary rules. But because trust in government is already so low, many Americans no longer accept institutional explanations at face value. What Democrats are increasingly arguing is that transparency cannot be selective. If politicians campaign on exposing powerful elites tied to Epstein, then they should not suddenly retreat behind procedural arguments once they hold office. Goldman's line of questioning reflected a broader Democratic effort to frame this, not simply as an investigation issue, but as an accountability issue. At the same time, Patel's defenders would argue that releasing sensitive investigative materials without proper legal authority could jeopardize victims, violate privacy laws, or compromise legitimate prosecutorial standards. That tension is real, and it explains why this issue continues to divide both Congress and the public. But politically, the damage may already be done. Because even without definitive answers, hearings like this reinforce the public perception that critical information is still being withheld. And once people believe powerful individuals are protected by different rules, rebuilding trust becomes extraordinarily difficult. This confrontation also revealed something larger about the current political climate. Americans are exhausted by secrecy, exhausted by elite protection, and exhausted by institutions appearing to say one thing in public while doing another behind closed doors. Whether you agree with Goldman's accusations or Patel's defense, this hearing showed just how combustible the Epstein issue remains years after Epstein's death. And perhaps the most important takeaway is this: the Epstein case is no longer just about one man. It has become a symbol of whether powerful people are ever truly held accountable in America. If you found this breakdown helpful, make sure to like, subscribe, and turn on notifications for more deep dives into major congressional hearings, political investigations, and the stories behind the headlines from a Democratic perspective.